Hey, why are you kids wearing those armbands?
We're protesting the Vietnam War.
If you wear them again, you'll be suspended. Conduct like that isn't allowed in school. It's disruptive. You're wearing it again?
Yes.
Come with me. You're suspended now.
The parents of the suspended children sued the school for violating their children's First Amendment right of free and symbolic speech. The Supreme Court rules students do not shed their constitutional rights of freedom of speech or expression at the schoolhouse gate. The Supreme Court assures their civil liberties and protects students' speech from being taken away from the schools. The District of Columbia Code determined it to be illegal to obtain an unregistered firearm and forbade handgun registration. Unless used for legal recreational activities, the district required that it was mandatory for owners of registered firearms to keep their weapons locked and unloaded. Only the chief of police was allowed to issue a one-year license on handguns. A police officer named Dick Anthony Heller, who went through registration to keep his handgun at home, had his application denied.
Hi honey, how was work?
I took 2 criminals today.
That's lovely.
I wish I didn't have to put a lock on my gun.
Officer Heller argued that this denial violated his Second Amendment right because it restricted him from the right to keep a loaded handgun at home. The Supreme Court applied the operative clause, which expressed that it is one's individual right to possess and carry weapons for the purpose of self-defense. Prohibiting the ownership of loaded guns in homes where one is originally in need of protection is unconstitutional.
Oh my god, these slides are horrible. They're getting rusty, don't you think? We need to resurface our playgrounds. Let's ask the state for help.
Trinity Lutheran Church in Columbia, Missouri had been denied money to resurface its playground. The court ruled that trying to separate church and state go to an extreme when they reject religious institutions to access government grants meant for secular purposes. Excluding churches from state programs is a violation of the free exercise of religion. Why is it hard for public figures and people to win libel and slander cases? To begin with, this is an expression not protected by the First Amendment. Public figures must show that defamatory accusations had malicious intentions and disregard for the truth. It is difficult for public figures to win libel cases because it is hard to prove that these statements were intentionally malicious. It is important for people to feel free to criticize public figures. For private individuals, they only need to show that the statements about them were defamatory lies and that the person behind it was denying it. People do not usually want to attract attention to harsh statements made about them. All in all, libel cases must balance the freedom of expression with respect for individual representation.
By creating procedures that allow them to infringe on individuals' freedom in certain occasions. Let's take the protection of the self-incrimination that is given to us by the Fifth Amendment. The Supreme Court in Miranda v. Arizona created the Miranda rights that informs you of your rights so that you won't be able to incriminate yourself, but to protect the public, they also created an exception called the public safety exception. This exception allows police officers to question suspects about weapons without giving a Miranda warning. If the interrogation leads the police to a weapon, it can be used against the suspect in court.
You're arrested. Tell me where the bomb is now.
It's 100 meters away.
792A. I got him. The bomb is 100 meters away.
Client was not read his Miranda rights, and because of this, his knowledge of where the bomb was should not be used as evidence.
Well, it seems that this falls under the public safety exception. Because a lot of people could have been hurt, we were going to keep this evidence in court.
Capitalist system. Here you go, my friend. Welcome, comrades. Do not submit to intimidation. Resist all drafts. They're motivated by the capitalist system.
Do not submit to intimidation.
During World War I, Charles Schenck, the secretary of the American Socialist Party, distributed countless leaflets convincing young men to resist the draft. He was then charged with disrupting the war effort. The court ruled that government could limit speech if it is causing a clear and present danger of substantive evils. Later then, the Smith Act of 1940 was enacted, prohibiting the encouragement of violently overthrowing the American government.
Wait, all right, here's the room. This warrant allows us to search it for just a little while, though, okay? So we gotta do this quick. Come on. All right. This is what we were looking for. Come on, we got it perfect.
Seems to me that this warrant is expired, and the search was illegal.
Your Honor, I had no prior knowledge of the flaw in the warrant, and I promise you I did nothing illegal during the search.
Seems to me that nothing illegal was done during the search, and that you had no knowledge of the flaw in the warrant. So, under the good faith exception, I'll allow the evidence to be used in court.
Exclusionary rule, a legal rule based on the constitutional law that doesn't allow evidence collected or analyzed in violation of the defendant's constitutional rights from being shown in a court of law, as used in Maps v. Ohio. The individual right being protected here is privacy, as state police are not allowed to search for evidence without a warrant to protect a person's privacy. Yet when a search is conducted with a belief that it is a legal search, the evidence discovered may be omitted, showing that although states are limited from infringing upon individual rights, there are exceptions that allow them to, if it's in good faith.
Hi, ma'am. Welcome to our center.
Hello, miss. I just scheduled an appointment for an abortion today.
Oh, I'm sorry, ma'am, but the clinic is closing down. You see, Texas just created a law that puts requirements on having abortions. One of them is we have to have admission privileges at a nearby hospital. The nearest one is 10 miles away. I'm sorry.
It's okay. Thank you.
On July 2013, Rick Perry, the governor of Texas at this time, signed a law that imposed strict requirements on abortion providers in Texas. Yet, on June 27, 2016, the Supreme Court struck down parts of the law to strengthen constitutional protection for abortion rights. The parts in question were: 1. Required all clinics in the state to meet the standards of ambulatory surgical centers, including regulations concerning buildings, equipment, and staffing. The other requirements were that doctors performing abortions have to have admitted privileges at a nearby hospital. The reason they took these out is because the states created more obstacles in the path of women seeking a pre-viable abortion. This case showed the Supreme Court limiting the states from infringing upon the individual rights of women in Texas. For selective incorporation, states argued that the Bill of Rights did not apply to them, and thus they could make laws infringing on our individual rights. An example of this would be the Jim Crow laws, which inflicted with the 14th and 15th Amendment, yet were still allowed till the 1960s. This is because the Supreme Court tried to use its privileges and immunity clause to apply the Bill of Rights to the states, but in the slaughterhouse cases, the Supreme Court held that the privileges and immunity clause of the 14th Amendment placed no restriction on the police powers of the states and intended to apply only to the privileges and immunities of citizens of the United States and not the privileges and immunities of citizens of each individual state. This put state law beyond the view of the Supreme Court. Thus, the court created a process known as selective incorporation, which is applying the Bill of Rights to the states through the 14th Amendment Due Process Clause. The First, Second, and Fourth Amendment have all been fully incorporated, while the Fifth, Sixth, Seventh, and Eighth Amendment have been partially incorporated. This means that although the right against self-incrimination has been incorporated because of Molly v. Hogan, the right to indictment has been by a grand jury hasn't. The Third Amendment, however, is weird, and it is only incorporated against states within the jurisdiction of the U.S. Court of Appeals for the Second Circuit, which includes Connecticut, New York, and Vermont.
You two, stop typing right now. You're under arrest for criminal anarchy. Put your hands behind your back. Stand up.
What are the Privileges and Immunity Clause? The Privileges and Immunity Clause is located in the U.S. Constitution. This means that a state cannot treat citizens of other states in a discriminatory manner. This clause has also been used to justify the right to travel, most prominently in Zobel v. Williams, where the Supreme Court agreed that Privileges and Immunity Clause, including a right to interstate travel. This issue, although, is not without controversy, as some do not view it that way.